Hey guys, it's Kathy. I hope you're doing well. We made it to another one. Sorry I wasn't ready yesterday, so I couldn't live stream. Jesco's here first. Well done, Jesco. Well done. So, I didn't realize, but Shaw sent me a clip. It was awesome. So we're going to start with that. I'm sure you guys probably all saw it because it was Travis County. So I'm sure they put it. It was great. So I'm sure they got it on all the big guys. Hey, Steve Miller. Let's get started. Let's just look at this clip real quick, and then someone else can translate, or I'll have to, and I don't know Spanish.
Mi hombre, sí, tú, López. Hola. No le hice nada a él. Él estaba hablando con solo. No me estoy hablando solo. No, López me dio por un lado, por una oreja. Pues puta madre, por allá. Por para atrás, toqué por un lado mío. Es que soy marico, ¿qué chingado? Por eso me estoy tocando los pinches orejas. Por eso me estoy tocando los pinches orejas, me tengo que ir a otro lado. Igual, puta madre. Es su madre, güey. Es su puta madre. Eres posible. Si no lo quieres por un lado mío, güey. Yo no quiero por un lado mío. Pero estaba por un lado mío, aquí por un lado. Sí. Para. No, yo no quiero sentar, me quiero ir a la cárcel. No, no voy a sentar. No me voy a sentar. No me voy a sentar. No me voy a sentar.
Esto no es aquí donde vas a estar haciendo tu pinche juego.
Ok, pues
Ya te lo que yo te digo.
no, pues aquí me quedo.
Quédate ahí
¿Qué me
entonces.
quedo? Pues le dije que se haga un poquito más para allá. No lo puedo hacer para allá.
Te dije que te iba a mover.
Chingados, ¿por qué me pegas a mí, güey?
Te dije que
¿Para qué me
te
pegas? ¿Para qué me pegas?
te vas a sentar o te vas a quedar en el suelo.
Pues no como quiera.
Ok, entonces ya está ahí.
Como tú
Aquí no
quieras.
vas a estar aquí.
Ok, pero yo tampoco.
Aquí se va a bajar la fuerza cuando la tenga que sacar.
Sí,
Ok, ya terminamos.
si quieres mandarme para atrás para la cárcel, me mando para otro lado.
Yo te voy a llevar cuando terminemos.
Ok, no termina. No,
So this is the thing I was telling you guys. Please, everything is being recorded. Everything
It
is being
sure is.
Don't make this be used against you.
pues le estoy diciendo bien, que se haga un poquito para allá, que está hablando de una oreja. Por eso me está tapando la oreja. ¿Por qué no ha visto que me está haciendo la oreja por un lado?
No estaba hablando conmigo.
Sí, eso fue lo que le tenés que decirle. Sí, ahora sí me puedo sentar. Es todo lo que tienes que hacer. Pero moverlo para allá. Todo lo que tienes que hacer.
All right, my Spanish is way rusty. But what I think they said was the guy sitting behind him took the last peanut butter and grape jelly sandwich at lunch. And the guy in the front, he had to eat the strawberry jelly and he was mad about it. So he didn't want to sit anywhere near that guy. But what this guy didn't know was the guard's mom made the strawberry jelly. So he was pissed. And that's why he was thrown to the ground. Don't mess with his mom's strawberry jelly. Just don't. All right. The next one we're going into, you're not going to understand anything. It's English any more than you did this video. You're not going to understand any words, but it's so funny because they're playing this in court, and I can't figure out why they're playing this in court. So, some family dollars were burglarized. All right. And this couple, we only hear the man here. Well, they went like hours away from their house and they hit like five family dollar stores in one day, and they only bought like toothpaste and shampoo, like one or two items at each family dollar store. There was no reason for them to go hours away from their house to buy these few little things and come back. Oh, that's right. Steve Miller had it better. Yeah, the guy's laying down. here. And the guard's telling him to sit up. And since he's so tired and he can't sit up, he can lay down on the floor. That makes sense. That makes a lot more sense. Fine. I was wrong, guys. Anyway, the dollar store people, the police interview this guy. And they play his interview tape in court. It's like a minute and 35 seconds long, and it's so funny because I don't know why they're playing it in court. And this is his police interview.
For everything got stopped. I guess the government supposed to be taking a lot of stuff away from the goddamn stove. So I mean, you been walking in the store. You don't been in the store lately, have you? I mean, you seen a lot of stuff out of stock, right? So I mean,
I hadn't really paid attention to the stocking because unfortunately I haven't gone to shop. I've been trying to find people who rob Dollar Generals. So.
That's just crazy, man. It's a lot of stuff. That's why we travel around and look at stove car. I mean, it ain't that many stuff, especially in Glenwood and down there. It ain't that many stuff in the stores, man.
Sure.
That's what I'm saying. So, yeah, man.
So,
hey.
So you're saying it's been tough trying to. Are you supporting your little sister? Is that what you're saying?
Yeah, man. Big time, man. I love my little sister, man. My little sister look up to me like I said, man. I'm the oldest. I mean, my mom ain't tell you, bro. I'm the oldest out of everybody, man. So
yeah.
Hey,
how much?
Seeing me like this, bro. That ain't knowing nothing. Making them like, damn, bro. I never even seen. I ain't never met for him to goddamn be sitting here like that, bro. Like, I ain't even be myself sitting right here, man. Like, last night, bro, I thought about the time I got there and got here, shit, I thought I was going to be able to go home. I was trying to talk to her. I just need a bond person. That's all I need to get out there and go home. That's what I'm trying to do. But like I said, I got the money right now to go home and go on and get my money. That hell, they probably done fire my ass by now, yeah. But like, too much really don't give a damn no more, cause this shit.
At this point in the interview,
For what reason? What did that prove? How could they use that? I don't think I can get demonetized for that because not one swear word was pronounced correctly. So that's this is in trial. I just thought that was hilarious. All right, now we're gonna go to Arizona, and they are special in Arizona. I just got to tell you that. Here we go.
Gotcha. Okay. What's state your full name?
Samuel Scott Deathridge.
All right, Mr. Deathridge, do you have a residence?
No.
Okay. Do you have an email address?
Do I have a what?
An email address?
No, I have absolutely nothing.
Okay. No phone either?
No, sir.
Okay. The state's alleging 4 charges against you. All of them are class 2 misdemeanors. The first one is unlawful acts regarding drinking. The second is public nuisance.
I can't. Can you please restate the first one?
Yes. Unlawful acts regarding drinking.
Okay.
The second one is public nuisance, dangerous to health.
Okay.
The third one is criminal trespass in the 2nd degree. And the final charge is failure to identify. Well, on those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for an arraignment on April 10th at 9 o'clock in the morning.
All right, what day is today?
Today is the 27th, so it's in about just over 10 days.
Okay.
On the charge, you have the right to remain silent, right to counsel, and right to trial. The arraignment is where you'll be prepared to give a plea of either guilty, not guilty, or no contest. Depending on how you plead will be what happens next with the court proceeding. Also, what will be explained to you at that hearing will be the maximum penalty and the mandatory minimum penalty, if any, apply. Your release conditions are the following. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if you obtain an address. Do Do not leave the state of Arizona without permission of the court. Do not contact any of the alleged victims in any manner. Do not go near the location of the alleged offense. And then, can you comply with those release orders?
So, sir, I'm going to have to tell you right now, I am still intoxicated. I do not understand anything you're saying. I cannot agree to anything or comply with anything right now because I am in fear that you guys are going to move me out of this jail right now when I agree to this, which in this state of mind, I do not want to be a danger to myself or to anyone else. This is why I do not want to do this. This is why I mean.
Yeah, okay, understood, but we don't go to your schedule, so we still have to have this, but here's what I'm willing to do for you, Mr. Deathridge, is I'm going to release you from custody, but that's only going to occur after 6:30 p.m. So you're gonna have an opportunity to sit there until 6:30 p.m., sober up, and then you'll be released from custody on these charges. You'll be provided a copy of this paper that I just read to you, and then you can comprehend it better at that time.
What don't you understand, guys? I can't. Do not release me.
Okay.
I need to sober up. I need to make some calls.
Okay.
I need to figure out what I need to do to not go hurt anyone, not go fuck off at school.
Okay, so that's why I'm not releasing you till after 6:30, so you have an opportunity to rest for a while. So that'll be all, sir.
Okay, Judge.
Okay, we'll get it sent over to you.
You know, every single guard that holds the camera for the judges all look almost identical. Anyway, do not release me. How could you do that, you bastards? And then we have people who have the opposite problem.
Thank you very much.
And
this is Judge Glowin.
We have a surprise guest in this video, and she looks really tired.
Calling two cases involving Mr. Stowater. Counsel, enter appearances, please.
For the city, Deshauna Sasueta, registration 53845.
Okay.
And Lauren Butler on behalf of Robert Stowater. We both appear over video.
All right, so it's my understanding there had been an appearance on Monday, an offer made at that time, and now we're back today. So Ms. Butler, you want to fill me in?
That's correct, Your Honor. Thank you. So on Monday's court date, the court set PR bonds in both of Mr. Stowater's municipal court cases. The offer is the same that was extended on Monday. At this point in time, Mr. Stowater has served the 3 days of jail time that was the recommended sentence. So even though he already got the PR bonds, today he would like to enter into a disposition and get a time served sentence.
Okay, so by that you mean plead guilty in both cases? And
that's correct.
Okay, and since I wasn't here Monday, was it 1 day in one case, 2 in another, or does anyone? I need to make notes here.
That is, I'll state it for the record. So in case 23-3889, there's one count of camping.
Right.
Mr. Stowater will be pleading guilty to that one count, and the recommended sentence is 1 day of jail, no objection to credit for time served.
Okay.
In the next case, it is 23-3302. There is one charge of camping and one charge of prohibited items. Mr. Stowater will be pleading guilty to both of those charges, and the recommended sentence is a total of 2 days of jail, no objection for credit for time served, with a total of 3 days of jail.
Okay. All right. So, Mr. Stowater, it's being proposed to just end these cases and have them completed at this time is that you would enter guilty pleas to those 3 charges, and the court would follow the recommendation, namely one day in one case, 2 in the next, give you credit, and the cases are closed. Are you ready to do that today?
Yeah.
Okay, so to the charge of, there's 2 charges of camping. To those charges, how do you plead?
Guilty.
All right, and then there was a charge of prohibited items. Usually that refers to just items related to the camping. How do you plead?
Guilty.
All right, I'm accepting those guilty pleas. You're represented by counsel. I'm finding you understand your rights. And
I don't have rights.
well, you may not feel that.
You guys have proven that. You guys will throw me in jail for camping, for sleeping on the ground. But for years, I've been begging for mental help, and not one of you, including you, Niat, will help me.
Okay. Well, I suspect we have a different view of that, but
We don't have rights. There is no innocent until proven guilty. You're going to jail whether you like it or not.
Okay. Well, I am
We always got
imposing.
jail still, but we don't have mental health that can do anything for you at all.
Well, I agree there's problems with the system, but I'm resolving these cases with 1 day in 3889 credit for 1 day and 2 days in 3302 credit for 2 days. So the cases are now closed. And from what I understand, Mr. Stowwater has a pending state case, so he remains in custody.
Pushed me to that point. What do you guys expect?
Okay. All right. Well, thank you, Ms. Butler, Ms. Sweta, Mr. Stowwater. Court's in recess.
Thank you, Your Honor.
Well, we all know that's not true. Niat and even the prosecutor Reynolds, they hate putting people in jail for camping. They have that whole community court outside. Come to community court. You know, we'll get you housing. We'll get you a cell phone. We'll get you food. We'll get you clothes. We'll get you a job. And they do it every week, and every week they do it over and over and over again. But I don't think he liked the rules of that. You know, like don't break the law, don't drink, don't do drugs. But he has no rights. No rights. Okay. Real quick housekeeping. I had been asked if I could turn off the participants in like the WebEx videos that don't belong there, so we just see the court, like the judge and the person talking. And I actually can't do that because it's a video, so I can't do anything about the WebEx videos at all. We just gotta watch them as we get them. Sorry, my cough break. All right. So if you guys saw my last stream, there was Georgia, a lawyer, arguing with the judge and asking for a mistrial twice or once, and not following the rules. Well, yesterday I think was day 2 and the end of that trial, and I have a short clip. It's only 2 minutes long. It's a little blurry, but he's raring to go again.
Mr. Spear.
Your Honor, this will be my last motion for a mistrial. I'm moving for a mistrial. Collectively, my view is that obviously during opening statements, I was told, or the jury was told that I violated a court order. During closing arguments, when the state made objections, the jury was excused. When I made objections, Mr. Buckler interrupted and said, "I'm going to talk anyways." And I believe collectively that has given the jury the understanding to believe Mr. Buckler, but not to believe me. And I think that would be grounds for a mistrial. And I think it's amounted to not you specifically commenting, but just because I call it the court, holistically, I think that has resulted in a court's comment on the evidence, and I'd move for a mistrial on those grounds.
I think he's arguing plain error. Judge, case law says plain error does not apply to closing arguments.
Well, I'm going to decline to grant the mistrial. When I sent the jury out during your closing argument, Mr. Buckler had asked for a bench conference. Somebody asked for a bench conference, but you had said we're no longer doing bench conferences, so I sent the jury out, ruled on the objection, sustained the objection, told the jury I sustained the objection because they weren't in here when we made the argument, and told you to continue with your argument. When Mr. Buckler was given his final closing and you objected, he said something about, I'm gonna keep talking. That was a response that was probably not appropriate. But I overruled your objection. So he could keep talking because he didn't violate the rules of evidence in closing argument. So I don't think there's a basis for a mistrial, and we've already beat that horse about opening statements.
Yes, sir.
So I'm gonna decline to grant your motion for mistrial. Anything else before we break for lunch?
No, Your Honor, you said back at 1:30?
So yes, the jury.
So if you don't remember, during opening, they objected to his opening, which you just don't do. It's opening. It's not evidence. So you just let the lawyer go on, but he broke a rule. Well, during closing, again, you don't object to the other lawyer during closing. They both objected to each other. So this guy was like, mistrial again. Okay, so after this is all over, and the jury leaves for the day, these two, the prosecutor and the defender, just are palling around, slapping each other on the back and joking and laughing. And, you know, how do men do that? I don't know, but it was funny. All right, this one is another short one, don't worry. And we never see her. And it's a shame. It's a damn shame that we don't see her, but we get to hear what she says anyway.
Can I have a breakout session with Jessica Kendrick? And I'm hoping while I do that, you would take up Marcus Smith as an out-of-county attorney with one case on our lovely docket today.
I was about to make that same request. That case is on Elizabeth Ward.
Okay, this is State of Kansas versus Elizabeth Ward, CLW 2022 CR 383. In this case, Ms. Ward, she's appearing by you. Is that correct, Mr. Smith? I don't see her up on the Zoom.
Your Honor, am I free to leave? This is Daniel Long.
You are.
Judge, I filed a motion yesterday to withdraw from this case. I was appointed to represent Elizabeth Ward by Judge St. Peter in a sync case. Her rights have subsequently been terminated and all communications have broken down with her since that time. I did send her a copy of the motion. She asked me to withdraw. She has stated unequivocally that she wants me fired and never wants to speak to me again. So I would ask to be allowed to withdraw.
Thank you. I did see that motion and I read everything was in the file, so I would be versed in that. The motion is granted and you are relieved and discharged for any further services to Ms. Smith in this case. Anything else I need to address for you, Mr. Smith?
No, thank you very much.
Thank you. Mr. Oddie, since Ms. Smith fails to appear, do you have any recommendation on how the court should proceed regarding bond and her failure to appear?
Well, Your Honor, she was present for the last court appearance on February 20th when it was continued to today. So I would ask for a bench warrant bond forfeiture.
Thank you. I do have that journal entry also in front of me, which does note that she was present with counsel at the last hearing on February 20th, and it was set for today at 9 o'clock. It is now 9:17. I will order, based on her failure to appear, that her bond be forfeited, that a bench warrant issue, and that she be held without bond until she appears before the court. Anything else we need to address in this case, counsel?
I don't believe so, Your Honor.
Thank you.
And now she's got a warrant out for arrest and no bond. But the good news, guys, there's good news. She never has to speak to him again, and he was fired. Okay, we're going to go to California. We're going to go to Sacramento, California, and we're going to go to this judge. The audio is not great, but this video is going to make you very, very uncomfortable by the time we get to the end. You don't even need sound. You can mute the whole video if you want. You don't need to hear a word they're saying. You just need to watch her, and you'll be uncomfortable by the end.
Because I figured we'd have people there. Yeah. Thank you. I'm here to help. As my old supervisor said, full service. All right. It's gonna get James. Apparently, I clicked to turn on the. All right, ready when you are. Yeah, it's me. Please.
I'm starting to feel very bad for her at this point.
You were delayed and you're not going to make this. I'll take the call. Mr. Fitzgerald, are you back?
I am back.
Yeah, here we go. 23 Dinkins. Latoya Chevelle Jenkins, is that your true correct name? That's my name. This is case 24 FE 008839. Also return on a sub warrant. You have 90 days. You're currently serving time until May 6, 2024. Public defender requesting appointment.
Yes, Your Honor.
PD appointed.
Stacey Jackson accepting the appointment. Ms. Dinkins indicates to me that she's asking for the court to consider re-referring her to work specifically. She's currently homeless, so to reconsider or to consider re-referral.
Has she been re-referred before? No. I'll re-refer her to the Sheriff's Work Project. She'll have to sign up by 5 court days from today's date is by April 5th. So from
My understanding is it is a long wait list, so I'd ask for at least 2 weeks.
my understanding is every other courtroom in this courthouse on home detention gives them 5 days.
Right, which is why we get so many people asking for referrals. Outside of this courtroom, we get calls.
My concern is that she's got to get it done very quickly in order to get it done by September 22nd. And I want to put her in a position that she can be successful. I'll give her time, but if they deny her because she doesn't have enough time left, that's my concern.
I'm just asking maybe for April 12th.
I'll go one more week, April 12th. You'll have to turn yourself in if you don't apply or not accepted. I'm gonna have your turn-in date be June 21st, 6 p.m. Archibald City. That concludes that matter. Do you want me to do the refusal or whatever this one is?
Which last name? Go ahead, step up, please. 62 Rogers.
Demisha Rogers, is that your true correct name?
Yes, thank you.
This is case 24FE005280, Wednesday, March 11th, 2024 through March.
She made it. She made it to the end, guys. She had to go to the bathroom so bad. There is no way at all that she heard anything that happened there. She was concentrating with all of her might on not going to the bathroom in that cage. And I'm not going to lie, I was watching the ground. She made it to the bathroom. I'm so proud of her. Okay, so I know that courtroom setup is weird. But this one, hi Dirty Sanchez, but this one, I call this video out of body. You'll see why. Because the camera angle is the weirdest camera angle I've seen. There's nothing crazy about this this video. It's just a 4-minute clip. But hi Deb, I just wanted you to see this camera angle.
Emily Gonzalez.
And the accent.
Francisco Perez.
Hello?
Okay, what's your name?
Francisco Perez.
Okay, 1 second, Mr. Perez. What's a DSC certification? What? Oh, defensive. Okay, so Mr. Bettis, you're missing a driver safety course certificate.
Yes, sir.
Driver's license record or driving record. Okay. Did you turn those in?
No, sir. No, sir.
Okay, why not?
I simply forgot.
Do you have them?
No, sir. I missed the due date.
Okay, so you don't have the driver safety course certificate? You didn't take the driver safety course then?
No, sir.
Okay. What? Did you just not want to do it or what?
I just forgot, sir.
You forgot?
Yes, sir.
Well, I'm not sure if I want to accept that, that you just forgot.
Understandable, sir. I thought the due date was a different date.
Yeah, but you didn't do it at all. So it doesn't matter what the due date was, you didn't do it at all. Right?
Yes.
Okay, so even if you knew even if you thought it was a different due date, you didn't take the time to go do it before that due date that you thought it was due. So I don't accept that either. Do you have any prior tickets to this?
No, sir. That was my first time.
How old are you?
22.
I'm going to reset you for 30 days. You have 30 days to complete this. If you don't, then that's it. All right.
Thank you so much.
So you need to come to the windows here. Where are you located, in McAllen?
I live in Mission, sir.
Okay, so you need to come to the McAllen Police Department building. You know where the McAllen Municipal Court is?
Yes, sir.
Okay, so you need to come You need to come over there and turn in your certificate and then your driver's license record, okay?
I'll do it right away. Thank you.
You get both of those. So I'm going to reset you for 30 days to get that completed, all right?
Thank you so much.
They'll email you information. All right, if you don't get the email, that's not an excuse either. Then I've already told you what you need to do. So even if you don't get an email, you can come, you can get what you need to get done and then come over here. But look out for any emails from the municipal court, all right?
Thank you so much.
All right.
So that was an interesting camera angle that we got to see. And it looks like it's that other lady's courtroom too, and she usually has the camera right, but I can't remember her name. Gonzalez? She has black hair. Oh boy. I can't remember her name. But it looks like this exact same courtroom, but maybe they all look that way in that part. All right, another quick one.
15 Brent.
So with this one,
Vernon,
this is a strong judge. She does not let anybody like push her around ever. And I mean, sometimes she gives breaks, but not often. She's a strong judge. But wait till the end of this one.
Bruce Brent, is that your true and correct name? This is case 22 FB 019476. On for return on stock work of 120 days. Your projected release date is May 8, 2024. Public defender requesting appointment.
No, Your Honor.
That'll conclude your matter.
No.
Sir, you owe that time right now.
No.
If you want to talk, I will appoint the public defender. You can speak to him. He would not be eligible for re-referral, just so you know.
Probation is.
Correct.
Curious to know if, I understand probation's ending next month, April 26th. He was curious to know if his probation could be extended.
I'm not willing to do that today. So you're gonna have to serve your time at this point.
I didn't know that. And that's the only reason why I didn't do that. But I didn't want to.
But here's the problem, sir. A year has gone by. And you were on 1 year probation. And at no point did you come in and contact whoever your attorney was to try and see if they could help you.
Know who my attorney was.
You didn't contact the public defender's office to ask for an extension on your work project. You didn't, and so here's the thing. I don't have any confidence that now that circumstances are going to be any different as to why you'd suddenly get it done a year later.
Like I said, I have a 78-year-old mother. She has COPD. She has arthritis. I got cancer. I got diabetes, and I got arthritis. It's not like I'm running around.
I understand you're not running around, sir, but all of those things.
I don't know that you just know.
Let me explain to you that all of those things seem to be are things as to reasons why you didn't get it done, or also reasons why you probably still wouldn't get it done.
No, I get it done. I get it done because, like, when I went there, they said I could not do it. They said you can't do it because you got a warrant in Placer County. That's the only reason why I didn't do it.
And you didn't get the warrant cleared in Placer County.
I got it cleared. Yeah, it's cleared. Yeah.
Right. And how long did it take you to get that cleared?
It took me, maybe about 3 months. I didn't know, you know.
And then
I don't know about, clear warrants except for going to jail. And,
Sir, here's the problem for me. I don't believe, like, you were rejected because you had a warrant, and rather than taking care of that warrant and getting sheriff's work project done, you sat and waited and hoped that they wouldn't come and get you.
No, I didn't hope that they didn't come and get me. I mean, they did come and get me, but I mean, I've been in Placer County, in Roseville, and they said, oh, you got this, in Sacramento. And like, I went to jail in Sacramento, in Roseville, and I had this warrant in Sacramento.
Sir, and I can appreciate all of those things. If you have a little over a month to do, and then you're done with your time. I'm not gonna re-refer you.
A little over a month?
May 8th is what you're looking at. It's March.
So I'll be done with probation and everything?
And you'll be done with probation and everything at that point in time. Sorry, sir. Medical visit will be ordered.
Thanks, Miss Megadeth. Oh, that was the wrong one. I was supposed to show you the one where she walks out of the courtroom. But that one was okay. He once he found out he only had a month to do, he was like, "Oh, okay." I didn't stream yesterday. Sally Port. Sorry, I wasn't feeling good and I didn't get enough. And Miss Megadeth, I really do appreciate it. Thank you so much. All right.
So here's the deal, Mr. Clark.
All right, let's check in with Christofino and see how he's doing. This is barely a minute long, so there was no way I could fix the audio. I mean, the audio is 30 seconds off. So this poor guy has had 5 heart attacks and 5 stints in like the last year, and he has Parkinson's disease, which is why he's shaking. And he's in front of Christofino.
As soon as I get this order done, and I'm not going to tell you it's going to be today. We don't work tomorrow because it's Good Friday. I couldn't if I wanted to. There's no electricity here. It'll be next week if I don't get it done today yet.
Your Honor?
Yes.
I know the medical here, they kind of want me gone immediately because I just got back from hospital again.
Well, you know what? You know
I
what,
can't get
Mr. Clark?
oxygen.
Then tell the stop talking, Mr. Clark. Then you tell the sheriff to go ahead and release you without an order. If he wants to do that, that's up to him.
No,
I don't
sir,
run
I'm not
the
saying
jail.
that.
I don't run any of that. I don't run
Okay.
any of that, Mr. Clark.
Okay. I'm just
And
saying,
Mr.
like I'm
Clark,
trying to tell
the
you.
more you keep talking, the longer I'll be on the bench. And guess what? The order will be sitting out there. I'll sign it, and it'll be there Monday morning to be sent to the sheriff. Stop
sir.
talking. Your
Okay,
hearing's
sir. Thank
over.
you so much. Thank you. I'm sorry.
Good luck. You got a lot going on. Good luck.
Thank you. Thank you, Mackenzie. Thank you.
So there really was nothing Christofino could do. He couldn't make it go any faster. He couldn't get him released right away because, the courts have to do the paperwork, send it to the jail. The jail has to do all their processing, and it's Good Friday, so I don't know what's open. So he might be there till Monday. I don't know. I don't know if they're able to get it done in time. Where is this? This is Indiana. I don't know what time zone they're in. But, maybe they got it done in enough time. But hopefully, at least with the medical staff they have at the jail, that they can make him comfortable until he's released, at least. Because he really literally does have enough going on. I don't know what his crime is. I don't care what his crime is. They need to get him out. Okay. Now, there's 42 minutes in this next clip because it's a trial. And I mean, it's best at the end when the guy who's getting sued is talking. But the first guy is pretty funny too. No, you're right. Well, I don't know. I mean, if he does have issues in there, could they sue the prison because they don't have the staff and the medical equipment to deal with him? I don't know. Hold on. Kelly's teaching us something. I love when she does this, guys. Okay, I found out. It's called a defendant's cage, and in the U.S., it is only still in use in Sacramento. They were mostly popular back during the heyday of the war on drugs. They are soon going to be phased out. But, if that other judge in Nevada would have had this, then we would never have had all those memes. All those wonderful memes. Yeah, I guess they could, Steve. They could just take him in an ambulance, just like if he was at home. He doesn't have medical equipment at home, so yeah, they could probably just get him to the hospital if he needs anything. I think he has a dog. He has a service dog at home that he has to be around constantly because the service dog is trained to tell him when a heart attack is coming on. So, he can grab some aspirin or something. So I think he needs the dog. I wish he could bring the dog with him into jail. But, okay. I'm not going to call these two hillbillies. I'm just not going to because that's rude. I'm just going to play the clip.
It got shot, right?
Mom, obviously it was sitting right there.
So you have no personal knowledge, correct?
No,
Okay. And you have no personal knowledge of what was in the toolbox at the time it was shot.
no.
Okay. And the list that you provided to the district attorney was a guess based on what you could remember, correct?
Yes.
Okay. Thank you.
Along with other things that I could not come up with because of family member stuff that could not be replaced because there was no place to replace it at.
So the list that you provided to the district attorney was based on a guess, correct?
No, it's what I had. It's what I had that I could remember what was inside of there. And then the things that was my grandfather's and my brother's are things that you cannot replace.
Okay.
So therefore that becomes more effective on, yes.
Okay, Mr. Hoffman, I have no more questions for you.
Mr. Hoffman, right now, sitting here on March 27th, how much do you think the toolbox was worth?
Well, upon looking at it, the toolbox was right around $1,200.
Okay, and
That is what I paid for it, but I looked it up used and it was worth more used, I mean, if you would like to look and right there, it's used. So if it comes to $1,200 and that $1,500 comes off of the price, then that $1,500 comes off of the price. And the $1,200 stays.
So I'll ask you the question in an open-ended way one more time. So sitting here right this second, how much do you think the toolbox itself is worth?
Probably right around $1,200, $1,300. Okay.
Ms. Fortner.
So Ms. Spradlin just asked you about whether you knew the date that the toolbox was shot up, and you stated that you didn't believe that you could answer that. So I want to let you know that now you can answer that. So what is the date that the toolbox was shot up?
The date that the toolbox was shot up, is it right if I look at my text messages now that we can say text message?
Sure.
Text message was sent to me showing pictures of it being shot. Let me see here. Let me get to this. I will show you the exact day that it was shot. It's right down here, Blue TJ. Looking forward to seeing you in court.
Court notes I'm allowing Mr. Hoffman to review his text messages on his phone.
That would be Tuesday, February the 7th at 11:21 p.m.
And you know this because Mr. Foster texted you and told you that he shot up your toolbox. And so regarding the price of the toolbox, so you went over a lot of numbers with Ms. Spradlin that you had given at different times for the price of the toolbox. Those were all estimates, correct?
That's correct. And then the one actual price that I did say was $1,200 when we looked and I found the price of it right here. $1,198.
Right, because you couldn't have anticipated that you would have needed to know the exact value of the toolbox before it was shot up. And so that 1,198 number, that's actually the cheapest price you found.
Yes.
Yeah, you found another one that was used that actually cost more.
Right. Because that was the sale price, $1,198.
Right. And so let's talk about the tools a little bit more. So same thing with the toolbox, right? You couldn't have known that you would have needed to have an itemized list of every single tool that was in the toolbox, right?
Correct.
But that was your best estimate based on the tools that you were missing.
Yes.
Because you were never returned the tools from Mr. Foster, were you?
No, I was not.
All right. Thank you, Mr. Hoffman.
Ms. Bradley?
Yes.
So you received a text message, you said February 7th, right?
That is correct. That was the night that he showed me. And actually,
Mr.
he
Hoffman,
even
sorry.
sent pictures of holes inside of the toolbox that night.
If you can please just answer yes or no to my question. So you were sent a text message on February 7th, right?
Yes.
You don't know when that photo was taken, right?
With everything else that was stated and how he said, I'm going right down here at waist level, it was that night, every bit of it.
All right, but you can't say when that photo was taken, right?
I'm gonna have to say it was that night because he sent it right
You
then and
believe
there.
the photo
It says,
taken
look,
that-
look what I just did to you. So there, I'm gonna say, yes, it was that night.
You didn't take the photo though, right?
No,
Okay, you received the photo that date,
yes.
and you believe that it was from that date.
Yeah, why else wouldn't he have sent it to me? Why would he send it to me at a later time when that picture was taken that day?
Okay, you didn't see him take the photo though, right?
No.
Okay.
Okay. Mr. Hoffman, you can have a seat. Thank you very much. Would you mind dropping those off before you leave? Thank you very much, sir. Next witness, Ms. Fortner.
No further witnesses.
Evidence, Ms. Strauss.
No evidence from defense.
Okay. Argument, in this case, the burden is the people's. People go first.
Yes, Judge. So the burden of proof for a restitution hearing is preponderance of the evidence. Ms. Spradlin argued that based on the conviction amount, Mr. Foster was convicted for M1, criminal mischief, $1,000 to $2,000, that is the cap of the restitution award. However, that is incorrect because the burden of proof is different at trial based on different from trial than from a restitution hearing. The burden of proof at trial is beyond a reasonable doubt. So even though that was the amount that Mr. Foster was convicted of damaging Mr. Hoffman's toolbox beyond a reasonable doubt, Mr. Hoffman still suffered losses exceeding that amount that can be proven by the preponderance of the evidence. I believe that by the preponderance of the evidence, the people have proven that Mr. Hoffman suffered monetary damages totaling $9,385 from this incident.
Ms. Spradlin.
Yes, thank you, Your Honor. First, restitution means any pecuniary loss suffered by a victim and includes, but is not limited to, out-of-pocket expenses, interest, loss of use of money, anticipated future expenses. But all of these numbers must be reasonably calculated and recompensed in money. I would first note that the amounts cited by Mr. Hoffman have changed throughout, and the list compiled was, as he testified at trial and mentioned multiple times today, was not a certain list of the tools contained in the toolbox. But before I get into that, I will point the court to 3 cases: People v. Knapp, 487 Pacific 3rd, 1243, People v. Cohen, 431 Pacific 3rd, 215, and People v. Sosa. The case law.
You could also add in Roddy. Roddy would be perhaps the most relevant in this case, Ms. Fortner. I'll give you the case side if you want it.
So effectively, when in a situation where a defendant is charged with one level of offense but is convicted only of a lower level offense, an award of restitution for that offense is limited to the amount consistent with the jury verdict. That is the main takeaway from People v. Knapp. In People v. Cohen, Colorado Supreme Court held that Colorado's restitution statutes do not allow a trial court to impose restitution for pecuniary losses caused by conduct that form the basis of a charge where a defendant is acquitted. And in People v. Sosa, the Colorado Court of Appeals extended this logic to losses that are proximately caused by uncharged conduct. In order to comport with procedural due process, restitution must be prohibited for losses resulting from conduct for which an individual has not been criminally charged, and as to which he retains the presumption of innocence. That is Sosa citing Cohen at 1208. A defendant may not be ordered to pay restitution for losses that did not stem from the conduct that was the basis of the defendant's conviction. That's a People v. Rivera, 250 Pacific 3rd, 1272. Citing People v. Brigner, 978 Pacific 2nd, 163. The jury in this case was asked to determine whether Mr. Foster was guilty of one count of criminal mischief between $1,000 and $2,000. That was the only charge against him, and that is the only verdict that the jury returned a determination on. Mr. Foster was accused of causing damage to the toolbox. He was convicted of criminal mischief for the damage to the toolbox. Mr. Foster was not accused, nor was he charged with damage to the tools that may or may have not been in the toolbox. There was no evidence presented at trial from either Deputy Nikolovska or Mr. Hoffman, the only witnesses that were called, that supported an inventory as to the contents of the toolbox or which, if any, tools were in the toolbox at the time the toolbox was shot. There was no testimony at the trial, nor today at this restitution hearing, that the tools were even damaged by the toolbox being shot. The only testimony elicited from Mr. Hoffman was that he believed that there were tools in there, but he wasn't certain, and he has no personal knowledge. Deputy Nikolovska did not investigate or seem to believe that there was damage beyond the toolbox, which is why Mr. Foster was subsequently, I believe, charged with a misdemeanor. We don't know when the damage to this toolbox occurred. We don't know who exactly shot the toolbox. And we know that the toolbox remained on Mr. Foster's property, but as the charges were amended against him the day before trial, there was an 8-month period where the people believed that the toolbox was on the property. I do not believe that the people have met. The case law also clearly states that although the burden of proof at a criminal trial is beyond a reasonable doubt, it is improper for a trial court to order restitution exceeding the amount that a jury trial found a defendant guilty for, because that would essentially be lessening the burden for an uncharged count. If the people wanted to charge Mr. Foster with over $2,000 in damage, then they should have charged him and put him on notice that he was going to be defending against more than $2,000 in damage. As to the source of the evidence of which tools were in the toolbox, that is based on guessing. There's no direct or reliable information that's been provided to the court to make the determination. So I don't think even the amount, which I believe exceeds what is permitted to be sought in this case, because Mr. Foster cannot be held liable for restitution from uncharged conduct or conduct that he was acquitted of. I do not think the amount asked for could be reasonably calculated. There was no testimony as to the exact make and model, nor was there any testimony elicited from Mr. Hoffman about which tools he believed to be in the toolbox on that day. The people are asking the court to both order restitution beyond the amount that Mr. Foster was charged with and convicted of, as well as order restitution completely based on speculation and hearsay as to the amounts. It would violate Mr. Foster's due process rights to order him to pay restitution in an amount beyond what the jury convicted him on and was asked to defend himself against. It would contradict Colorado case law to order him to pay restitution for conduct he was never charged for.
Given the nature of that argument, if you want to respond, Ms.
Yes, Your Honor. I would just note to the court that there was testimony both at trial and today that there were tools in the toolbox at the time, and that based on the position of the multiple bullet holes that Mr. Foster put in the toolbox, that the tools would have been damaged by the shooting. Mr. Foster was convicted at trial of criminal mischief, $1,000 to $2,000. The elements of that offense are that the defendant in the state at the date of place charge knowingly damaged the real or personal property of one or more other persons, including personal property owned by the defendant jointly with another person, or property owned by the defendant at which at the time of damage another person had a possessory or proprietary interest in the course of a single criminal episode. The people proved all these elements beyond a reasonable doubt at trial. There was testimony at trial that the tools would have been damaged. There was nothing the charge is criminal mischief. It's not confined to just the toolbox. Mr. Foster's personal property was damaged, both his tools and his toolbox. I don't believe that the amount of the, based on, I don't believe that the $2,000 amount of the M1 conviction limits the restitution that can be sought. So for that reason, the people are asking the court award the full request of restitution.
Okay. Ms. Spradlin cited Knapp, Sosa, and Cowan. I read all three of those cases earlier this morning. I also read People versus Roddy, or at least, and I should say I read the relevant portions. Knapp covers a lot of topics. As an example, it's got a printed copy here. It's nearly 20 pages long. Much of it deals with things that are not relevant to this matter. I'll start by...
Judge, can I add something?
Mr. Foster.
I'll reopen evidence if he wants to testify.
Yes, please. Yes.
We're not getting sad. I don't want sad. If it has 3 weeks, man, I can get out of there.
Why don't I let you all... Ms. Spradlin, could you just talk to Mr. Just go out in the ante room, and
Okay.
if he wants to testify, I'll reopen evidence.
I don't remember them going into the other room, so I don't know how long they're going to be there, but I don't think they'll be there long. Oh no, I was just lifting my voice at the end of my sentence. I think my last stream tainted me forever. This courtroom. Yeah, stop talking about your case, please. No, we want him to talk. He's the star of this show. Once he says what he says, you might not think what he did was just so bad. I mean, it was bad. It was bad, all right? I'm not saying it wasn't. All right, I'm going to use technology.
Found that Mr.
Hold
Foster...
on, I'm putting it back. All right, we'll just... Here they come.
Ms. Spradlin, what would you like to do?
The defense still does not wish to call any witnesses or present any evidence.
Okay. So let me give a bit of a history of this case. There was clearly evidence at trial and today that, first of all, let me cover the obvious. The jury found that Mr. Foster was guilty of criminal mischief. I respect the jury and the decisions of the jury. The jury had a verdict question and determined that the damage to Mr. Hargrave is between $1,000 and $2,000. I'm reading from the amended complaint that I approved over defense's objection for the single count of criminal mischief, and I will just read it. Between and including May 1, 2022 and February 13th, 2023, Michael Foster, in the course of a single criminal episode, unlawfully and knowingly damaged the real or personal property of another, the aggregate damage being $1,000 or more, but less than $2,000 in violation of CRS 18 4501 1 and 4C. This issue has been, so the question is, I note that the jury said the damage was between $1,000 and $2,000. That is the level of the charge. They were given the other misdemeanor options and chose neither of those. He was very obviously, Mr. Foster was not charged with a felony. That's why his case was pending in county court. As I indicated at the outset, I read this morning, or maybe yesterday, but very recently, Knapp, Cowan, Sosa, but also Roddy. I'll give you that site. It's 2021 CO 74. The key language is up, paragraph 27. I'll start by covering Knapp. Restitution in criminal cases is part of a trial court sentencing function. This is at paragraph 71. I should note that Knapp involved acquitted conduct. It then references the restitution statute and the terms and the language of that statute. The court goes on that we liberally construe the restitution statute to accomplish its goal of making victims whole for the harm suffered as a result of the defendant's criminal conduct. However, a sentence that exceeds a court's statutory authority is illegal. Our Supreme Court recently made clear, this is they're citing Cowan here, that Colorado's restitution statutes do not allow a trial court to impose restitution for pecuniary losses caused by conduct that formed the basis of the charge and of which the defendant has been acquitted. In other words, when an individual has been acquitted of one charge and convicted of another, the court conduct underlying the acquitted charge cannot serve as a basis of a restitution order. Of course, in this case, Mr. Foster wasn't acquitted of a higher charge. He was only but he was convicted of the Class 1 misdemeanor. Knapp goes on to cite Cowan to say that a contrary holding would raise constitutional concerns in the wake of the United States Supreme Court's case in Nelson versus Colorado. Absent a conviction of a crime, one is presumed innocent. Colorado may not presume a person judged guilty of no crime, nonetheless guilty enough for monetary exactions. The case goes on, but I think I'll switch. I will note Sosa. And Sosa was cited by Knapp in footnote 4, noting that a division of this court recently held there was also, it would not be proper that trial courts could consider uncharged conduct as a result of determining the amount of restitution. Finally, I'll cite Roddy. This is at paragraph 27. I'll give you a cite for it. 498 P 3rd 136 2021 CO 74 paragraph 27. First of all, it cites Sosa. I'll just go through the language. In Sosa, the defendant was charged with accessory to first or second degree murder based upon a drive-by shooting. As they cover the plea agreement. Rowdy then comes, extending the reasoning from Cowan. The division concluded that when an individual is not charged with a crime, she, or in this case he, cannot be found guilty of that crime and cannot therefore be deemed an offender under the restitution statute because she, or he is by definition not a person who committed the crime charged. So any conduct underlying the uncharged crime cannot be deemed the conduct of an offender. As with conduct underlying acquitted charges, due process demands that defendants retain the presumption of innocence with respect for conduct for which they are not charged. Well, as I just read in the complaint, the charge, as clearly set forth in the complaint, was between $1,000 and $2,000. I believe, based upon the jury's determination, that my number starts at $1,000. I cannot award less than that based upon the verdict question answered by the jury. The question that I had, and I will tell you, I've discussed this with 2 other judges as well as doing one district court judge, one county court judge regarding this. And the conclusion based upon Knapp and Sosa and Cowan and Roddy is that I am limited, at least the conclusion I come to, is that I am limited to the amount awarded by the jury. So that is, I hereby find that the maximum amount I'm allowed to order under that case law is $2,000. Now we move to the facts at issue. There is no doubt, absolutely, positively, unequivocally, Mr. Foster is liable for the damage to the toolbox. I asked Mr. And he was asked also, it was a little vague on counsel's questions, that's why I asked, how much he believed the toolbox was worth sitting here today. He referenced, and I took a look at 2 RH indicating it was $1,198. He indicated that was a sale price, which I take it at face value, and that the actual price would be $1,250, or he said between $1,200 and $1,300, the midpoint being $1,250. He then testified as to the tools. It is clear to me, based upon the testimony at trial and today, that tools were left by Mr. Hoffman in the toolbox, and I make that finding. I also find, based upon the jury's verdict, that Mr. Foster shot up the toolbox and at the very least did not return the tools. Certainly there was no indication that they were ever returned to Mr. Hoffman. He estimates the total value of the tools, let me pull up the number, at today's hearing to be quite a bit, in excess of $8,000, I believe, $8,187. I know he bases this based upon our Exhibit 1RH. Oh, I know it was here. This was consistent with his testimony at trial, or generally so. I thought it was in here. Give me 1 second, folks. Oh, it just separated. So he was asking, even at the outset, as evidence on the victim impact statement, 1RH, that he was asking for 8187. He then attached a list which would support, and the toolbox was worth $2,000. The court finds that there were tools in the toolbox, and that by shooting, for some ungodly reason, for shooting up the toolbox, Mr. Foster damaged the tools. I accept Mr. Hoffman's value because I generally find and now find that you can testify about the value of your own property, and I accept his valuation of $8,187. Having said that, based upon the case law I just cited, I don't think I am permitted under Cowan or any of its progeny to award in excess of $2,000. Among other reasons, in addition to the case law, that was the amount that Mr. Foster was placed on notice would be sought. Had the people wished to charge a higher charge, they certainly could have done that, but chose not to. The court hereby finds that the actual amount of restitution would have been, I'm going to make a finding that I'm going to take the midpoint of Mr. Hoffman's number, $1,250 for the toolbox, and well in excess of $750 for the tools. It could perhaps as much as $8,000. But based upon the case law cited to me by Ms. Bradlin and that I reviewed this morning, my award is limited to $2,000. I award $2,000 in restitution. Okay. Sentencing is, I don't really have a preference in this case how we go. I'll go the opposite direction from what I normally do. Ms. Fortner, what are the people like? Or Mr. Sullivan?
Your Honor, I'll be doing the sentencing argument. So I'll note off the bat, besides the restitution award, the people are asking for $34.35 as cost of prosecution.
4.35?
34.35.
34.35, okay.
For delivery of subpoenas and service by mail. Then when we come to sentencing for Mr. Foster, I've been wrestling a bit on whether or not I should ask for jail. I would note this is a property crime. I see it as aggravated in that it appears that Mr. Foster purposefully and intentionally, and not necessarily in a heat of passion, at least Mr. Hoffman wasn't there for this incident, decided to significantly damage by a great amount Mr. Hoffman's property. And I think the way that he did it by shooting it is concerning. The amount of bullet holes in that toolbox certainly evidence a degree of malice there. Then Mr. Foster, when he spoke with police, he gave this idea that I feel like it's mine because it's been here for a minute, but also he essentially did what the obvious implication is admits to doing this act of criminal mischief. And yet since then, he has not returned the toolbox or the tools to Mr. Hoffman. He has not taken any responsibility for his actions. And I think that is very noteworthy that he did not take any responsibility for all this damage, significant damage to Mr. Hoffman's toolbox. And based on that, Judge, I do think punishment is appropriate in this case. I do think it showed a very concerning lack of respect for other people's property, and amount of malice towards Mr. Hoffman. And so I'm asking for 21 days jail.
Okay.
If the court does not order jail, I think a very, very substantial amount of useful public service would be appropriate if the court does not order jail.
Okay. Ms. Patton?
Mr. Honor, first I have a concern with regard to the restitution order. The jury was asked, was the aggregate value of damage to real or personal property $1,000 or more, but less than $2,000?
I can make it $1,999.99.
I think that to order.
Good
to
job,
order
lawyer. Good
$2,000
job.
would contradict what the jury made it.
Okay. The court, for legal reasons, as stated by Ms. Spradlin, the award is $1,999.99.
And as to sentencing, Mr. Foster has very little criminal history. Mr. Foster runs a business in the community. Mr. Foster cares for his elderly mother, who was briefly featured on body-worn camera at trial. This is the jury determined that Mr. Foster was guilty of causing the damage to the toolbox. I will note that the toolbox had been left on Mr. Foster's property for at least some period of time. And so, Mr. Foster did make multiple attempts, as there was testimony at trial, to facilitate the return of the toolbox. At one point, Mr. Foster's belief was that, the toolbox had been abandoned after his multiple attempts to return it were not executed. We heard from Mr. Hoffman that at least on one occasion, Mr. Foster put the toolbox outside of the shop and said, hey, you can come get it, and it didn't get picked up. So I do not think that this is the type of crime where the allegation is damage to property, is the type that warrants a jail sentence. We would be advocating for a unsupervised probation period based on Mr. Foster's lack of criminal history. I will also note that the incarceration of Mr. Foster would likely disturb his business and disturb his ability to pay restitution, which he's just been ordered to pay, which I don't think is really in the best interests of Mr. Hoffman in becoming whole. And I'll just note that the only two individuals who live on Mr. Foster's property are he and his mother has medical needs and is dependent on him. And so for that reason, we're asking the court to order unsupervised probation for Mr. Foster.
No, I recognize this isn't a VRA case, but Mr. Hoffman has been nice enough to come over the hill. Mr. Hoffman, do you wish to speak? If you do, come to the podium, start with your name. And if you don't, that's okay. But I'm going to give you an opportunity to say whatever you'd like to say. And then counsel will go around again if you want to say something after that.
Sir, the man has big time problems with anger. And so maybe some time in jail would make him think about this. If not, you should give him the most supervised probation that you possibly can, because I've seen him this way with other people. And so therefore I feel that he should be the most supervised that he can get if there is no jail time.
Thank you, Mr. Hoffman. Okay, Ms. Fortner, anything in response to that? Or Mr. Sullivan, I'm sorry. No, Ms. Spradlin?
Yes, I'll just note this case has been pending for a year. Mr. Foster has not had any other cases put against him. So I think to whatever extent Mr. Hoffman is concerned, Mr. Foster is not demonstrating that he cannot be safe in the community or be a productive member of our community.
Okay. Mr. Hoffman, if you could have a seat, I'm going to talk to Mr. Foster a little bit. Mr. Foster, when people enter plea deals, they waive their rights to remain silent. But Ms. Spradlin intimated that, but you didn't enter a plea, you were convicted by jury. So you haven't waived anything. And Ms. Spradlin has indicated she might appeal. So I simply alert you to your Fifth Amendment right to remain silent if you wish. But, and at any point, even if you decide to talk, if you wish to not talk or not answer a question I might have, you are free to do so, and you're free to talk to Ms. Bradlin about that. I can mute the calls. And I've muted you both. Yeah, Ms. Bradlin, I've muted you. So you're good.
They only talk for a moment. They'll be right back.
Okay. I note that Ms. Bradlin, I had muted both microphones. Ms. Bradlin was talking to Mr. Foster. Mr. Foster, do you wish to say anything?
Well, one, my mom's completely dependent on me. She's in bed completely all the time, for one. The second thing would just be that he was asked 10 times to get it out of there. 3 weeks before he was asked to get it out of there. So when someone refuses to take something out that I want out of my place, and I don't assume any responsibility for it because he refused to take it out. He's invaded my home, harassed me endlessly, walked into my home unannounced. And I said, "What's with the toolbox, dude? I'm trying to be cool. I don't want conflict. I avoid conflict. You know, I avoid conflict. Not a word.
Sure
All he does
he
is
does.
meanwhile walk back to his toolbox, fiddles around with it for 20 minutes, walks back out of my home. And I said, "What's with the toolbox?" Just completely ignores me. So he refused. And the amount of harassment that I received from this guy is unreal. This is my home. This is my home, my place. I won't be harassed in my own home. He had plenty of chances to get it out of there. Get it out of here.
Why did you shoot it? And I should note, any question I ask, just if you tell me you'd rather not speak, I won't answer. But why did you shoot it?
Well, it's not proven with reasonable doubt that I did.
Yes, it is, Mr.
I didn't admit to nothing. Well, I'm going to stop there. I'm going to
Okay,
stop there. Yeah,
again, for the reasons I said, I'm not going to require you to speak.
my only point was when I asked somebody to get something out of there I don't want to be harassed by somebody who's got their stuff there. Get it out of here. He had plenty of time to do it. I wasn't even there when it came. I didn't want it there. There's no benefit in it for it to be there. This is a hassle. All I'm doing is getting hassled by this guy, and that's what he wants. That's all I got to say about it. I'm not saying anything. I'm just stating some reality that hasn't been stated in the trial or anything else. There was multiple opportunities to take it out of there, and he just refused.
Okay. I feel confident that both Mr. Hoffman did not have everything presented at trial that he wanted presented, the text messages being the obvious example. Mr. Foster also very clearly does not believe that everything was presented. I note that I have no indication that these tools were ever returned, or the damaged toolbox was ever returned, or that any appropriate action was taken to mitigate damages. I note for Mr. Hoffman's benefit, to the extent there's an entire civil proceeding, either replevin or tort actions that can be pursued, and my determination of restitution in this case is not a bar to additional damage. It is clear to me, Mr. Foster is angry. Right, he was angry right here, right now, in front of me. He was angry enough to shoot up another person's property. Mr. Foster says, well, there's no proof of that. In fact, there's something much better than a proof. There is a jury verdict to that effect. So the court takes that fact as true. Yeah, I'm done, Mr. Foster.
Okay.
The criminal history, you said that was light, and I did a brief search, but Mr. Sullivan can tell me. And
So I know he has 3 prior DUIs because I prosecuted one last year, and that was a 3rd conviction that's being appealed right now. Do you know any other criminal history? I don't think he has much. I know he had a dismissed case, so I wouldn't take that into consideration. I don't
So
think he has
outside of the
substantial
DUI.
criminal history other than the DUIs. If Ms. Forner finds anything.
Yeah, I think I agree with Mr. Hoffman here. I mean, I think the issue here is anger, given the criminal history. Again, Mr. Foster is angry right now, and I I think that's an issue. I have no idea whether he was intoxicated or not, and nor am I making that finding at the time of this mischief. Given the lack of criminal history and his personal responsibilities, I think what I'll do is impose jail but suspend it. But I think Mr. Hoffman's correct. Supervised probation with anger management is the answer. Court imposes 60 days jail, all of which is suspended upon successful completion of probation. Probation is for a period of 18 months. State supervised probation. Standard conditions will apply. In addition, Mr. Foster shall have an anger management evaluation and comply with any and all recommendations set forth therein. I'll add in some useful public service because I think that's helpful. I'm not going to add a huge number, but something that can be reasonably effectuated in 18 months. Give me 1 second, please.
And that was it. He took the stream down. But we saw what we needed to see. We saw what we needed to see. I can't say I agree with the judge. So if someone leaves something at my house and, I tell them, you got to pick it up, you got to pick it up. I leave it outside. I say it's outside, come get it. After a while, they really did abandon it. Now, I probably wouldn't shoot it up, but maybe I would. Who knows? If it's a Tuesday, I probably wouldn't because I'm tired. But if it's Friday, maybe I would. But I would definitely get rid of it. I wouldn't just leave it at my house. And if they came over and walked into my house to use it and then didn't take it with them, in the trash it goes. And then, the police would be called. But yes, I just... Was he angry? Does he have anger problems? Probably. Absolutely. He sent a text message saying, here's your toolbox with all the bullet holes in it, which is just rude. He knows how much men love their tools. He knows. He knows that was just wrong. Yeah, they lose their rights to it if they abandon it. They just do. But, well, he's going to have to pay $2,000. And if they do a civil trial, which they can, the judge said that they can, he's going to owe $7,000 more. And he's going to have to, make payments to him every month. Oh, gosh, that's gotta be a hard check to write every month. Poor Cha is sitting with no electricity, charging the phone. You missed the beginning, Cha, where I played your video. The video you sent me. It was very, very good. But then I was wrong and Rome was right. I don't know, Kelly, you are. Why wouldn't you be allowed? If he had priors that were assaults or aggressive, that would mean, that would mean a lot to what's going on. Or mistrial. Oh man, he should have said mistrial. Why didn't they say mistrial? All right, guys. Thank you so much for coming out today. I really, really appreciate it. I will see you again soon. Hopefully I get enough content. What is today? It's Friday. You're number one of the rewatch crew. And Sally, thank you so much again for the gifted memberships. Appreciate it. And Miss Megadeth, thank you so much. Really, really appreciate it. You guys behave today because I don't know. I don't know if all the courts are open on Monday because it's Easter. And I don't know if any judges are working today. So just don't get arrested today. Where's that? Kelly, I think that was Colorado. Hold on, let me start it again. I'm not going to play it again. I'm just starting it so I can see.
Right.
WebEx. Nope. Yeah, it's in Mesa. It's Colorado. All right, guys. Have a good day. I will talk to you again later. Behave. See ya.